Thank you so much. This has been an amazing forum so far, so thank you very much for organizing this. And I want to bring it back to you. So everybody in this room will need a doctor once or twice in their life. If you don't need a doctor, your child or your parents might need a doctor. And what's happening in Australia now? So last year, 20% of medical clinics were using AI scribe. Today, 40 or maybe 50% of medical clinics are using AI scribe. So this is not the future, this is today. Your information, when you go to GP, is used by AI, processed by AI. Some of it is processed not in Australia, some of it is processed overseas. And if you read Guardian yesterday, what the regulators are saying that we should be watching the use of AI by our medical practitioners. Who is watching? Privacy Commissioner is watching. TGA has been mentioned. Therapeutic Goods Association, Administration Authority has been mentioned already. They are watching. Who else is watching? Department of Health Commonwealth. Who else is watching? Department of Health at the federal level. So New South Wales, Victoria, NT, and you name it. Who else is watching? Parliament is watching. So contrary to some IT companies, AI companies that want to come into Australian market and are presenting AI landscape in Australia as a Wild West that has no regulation. As a lawyer, I want to really spread the message that law is already existing. Australia chose to rely on existing framework of legislation, and that's what we are doing here, regardless of the fact that AI Act has not been enacted in Australia. Regulation is quite robust. So all organizations should manage AI accordingly. Law already sees you, and today I will leave you with the system that each organization should use in order to show law what it wants to see. This is a little bit about me. I am a lawyer, 15 years plus in practice. I'm researching actively in AI. So if you need my further work on, with further deeper analysis of legislation, of exact acts or cases, please feel free to reach out. I'm also on working groups with nationally, internationally, with a community of legislators in the Commonwealth. So enough about me. The main argument of this presentation is that law sees you, there is law, and what you have to do in your organization to see it, control it, and record it. And we have seen already the growth of AI is exponential. Yes, we have seen amazing LLM models. What we will see is agentic AI in the future. And what I'm making sure, so I'm also AI governance chair for our own law firm, which has 2,000 people. But I'm making sure that we have robust systems to protect in terms of agentic AI as well, which is coming into the future, which is coming very quickly, actually. So Australia chose legal continuity. The current law map is already drawn. Shadow AI is a visibility problem, so we will stop on it and we will discuss it. Targeted reforms are already in train, and each and every organization must build the model that works for them. Doesn't matter. I have non-for-profit clients, they're coming to me, local government councils, they're coming to me, and all of them have to build their own robust AI governance system. It depends on each organization and depends on their needs, but AI governance system must be built within each organization. Here are some of the acts that are already governing AI. If you would like the full list, again, please feel free to reach out. I have the full, not exhaustive list, because new legislation is coming out. So we have, of course, Privacy Act, Corporations Act, that is governing director duties, discrimination. The first panel was talking about the possibility of discrimination. If AI systems are discriminating against the workforce and you have evidence to prove it, yes, you should go to court. There's no questions. Same with the Disability, Racial, Human Rights Act. There is a already robust framework that is existing. So, yes, we are not enacting AI Act as European Union, but the targeted reforms are sufficient to take even our duty, care of duty obligations, even if we are talking about duty of care legislation for manufacturers. You must not forget, common law is existing, duty of care is there. Donoghue and Stevenson, I don't know, so how many lawyers are in the room? How many lawyers in the room? Couple, fantastic. So, Donoghue and Stevenson, it's the snail in the bottle, manufacturer's liability. This case is still existing, and just couple of pieces of legislation that are already in force. Out of all jurisdictions, New South Wales is the most amazing in the fact of work health and safety. You have the new Digital Safety Act with work health and safety obligations for AI systems not to harm employees. Cybersecurity has been mentioned. SOCI, that security of critical infrastructure, has been mentioned already. Confidentiality obligations. As lawyers, we have legal professional privilege, consent. So if you are going to GP and your information is recorded by AI without your consent, there are implications there. Of course, you have health records legislation. You have procurement and vendor obligations. Don't forget about the contracts. That's the key difference between all other obligations in Australia compared to AI obligations. Vendor terms and procurement terms are more important than in any other case. And I remember you asked in the previous session the question about regulation, how AI systems should be regulated, whether the regulation should come from the companies, manufacturers, or whether this regulation should come from regulators. Of course, the answer is both. It should be self-regulation by manufacturers, and we already are seeing the signs of with big corporations, including ethical divisions, ethical AI divisions, and of course, government should regulate as well. And of course, that will never be perfect. Or maybe we will be able to build the perfect world. We did hear from the previous panel that there is a possibility of building the perfect world where maybe it will be perfect, maybe it will not be perfect, but there are obligations that are already existing. First problem is visibility problem. Dom already was talking about visibility in different contexts, of visibility of incidents. I'm talking about visibility in terms of use of AI by employees. So what's different between AI as opposed to different other technology systems is we have these beautiful mobile systems, mobile phones that we are all using. And I was at the National Community of Practice Regulators Conference in August last year. And we had great presentation from defense. And even in defense, it's difficult for them to stop people from using their personal devices with AI systems. Even if it's difficult even for the defense. What do we talk about our simple organizations that our clients, everyday clients? So 1 in 4 workers is using AI at their workspace without declaring the use. Three others are not. 3 others are lying. 3 others are lying. Okay. So the risk of AI starts with the input, with the information, with the data. Data is inputted, inserted, included into some tool, which uses authorized or not authorized, and then there was an output, and then there was a decision was made. Was this correct decision? Was it not? We can't test, we can't verify, we can't do anything because we don't even know where the information was included. Could this this output break consumer law? Australian consumer law has been mentioned already. Could this lead to misleading output? Yes, it could. Could it breach the director duties? Yes, it could. Section 190 of our Probations Act. Could this breach employment law, anti-discrimination law, work health and safety obligations? Can the decision be an automatic decision that can be explained and justified? So that's the use of AI in governments. With recent privacy reform, so we have automated decision monitoring reform that are coming in. New South Wales, I have touched on New South Wales. E-safety codes have been quite a loud reform throughout the world. Australia, all around the world, people were reaching out to me and saying, oh, that's a wonderful reform for the future. Within Australia, we thought that the reforms were not implemented sufficiently well. And then we have, of course, December 2026, when automated decision-making reforms are coming into place. And that's something that we should be aware of as well. Couple of regulators that are already in the space, and Information Commission has been mentioned, ACCC has been mentioned, ASIC, Australian Securities and Investment Commission, hasn't been mentioned so far, APRA, Insurance, hasn't been mentioned yet, but and of course, AI Safety Institute, not quite a regulator, but still on the board, so there's definitely work that is happening in the space. What are the three main fault lines so far in regulation of AI? Liability. This has been already mentioned in the fact that it's difficult to attribute liability. Who is responsible? Is it the manufacturer that is responsible for the system? Is it the person who actually put the information in? Is it the decision maker? Is it somebody else? So there is no clear attribution just yet, but wait and see. And the courts will come with a certain way of deciding this as well. Opacity, maybe even 5 years ago, we were talking, I remember at the conference, we were still talking, because of algorithmic opacity, we can't use AI. You're nodding, yes, that was the conversation 5 years ago. Nobody has this conversation now. Not one person is saying, we can't explain the decisions that OpenAI or Anthropic is coming up with, that's why we can't use the system. So this conversation dropped off. And autonomous behavior. This is something that we will be coming into with agentic AI for sure. And that is something that we definitely have to think of more. Working risk map, scale of control. Of course, this is not decisive, and of course there are differences between organizations, but usually when we are talking about internal drafting, so internal email, internal agenda for the meeting, that we usually are talking about low risk. When we are talking about, for example, law firms, client or doctors or lecturers, we are talking about student-facing, client-facing work. Of course, the risk is elevated. If decisions are affecting rights, obligations of humans, so we are talking about AI use in courts, that's the risk is high. And in this case, of course, we are talking about mitigation. In mitigation, we are talking human in the loop at all times. But, and we did discuss it, I can't see the person. Okay, no, we did discuss it with the presenter in the other room, that some legislation already allows for automated decision-making without the human in the loop. And this legislation has been enacted in Australia. I came across it only this year. So it's something that will be definitely subject to consultation in this sense as well. So what every organization should have, regardless of size. Inventory, what AI tools we are allowed to use or what AI tools we are not allowed to use. Policy, it doesn't have to be sophisticated. It can be even, I was talking to one client and they asked me, can we include it in our cybersecurity policy? Yes, you can. And another client asked me, can we include it in our records keeping policy? Yes, it's closer to data. Yes, you can. Training. So basically, there's no point talking about AI if the literacy about AI is so high. Unfortunately, we do have low literacy, and unfortunately, I have never talked about the topic, and I have done research about different legal topics in these years, but I have never talked about the topic that has more mistruths than AI. Risk tiering, so of course we are matching the risk to the harm. Human oversight. I don't think we are at the stage, I don't know, of course, different industries might have different views, but I don't think in legal sphere or in medical sphere, I don't think we are at the stage of talking no human in the loop. We are talking always human oversight is something that is required. Vendor review. More than ever, contract terms of the vendors are important. Records, of course, that's always documents, and documents must be kept legally for 7 years, in some cases for 3 years, but I'm always telling my clients to keep records for longer, just so you can protect yourself against any action. And of course, audit and ownership. So every organization has to have accountable people, and the documents have to be audit ready. Okay, how do we handle data? Does data leave Australia or not? What's in terms of intellectual property of owning IP, liability, and again, audits. This is important. What I think every organization should have, probably, okay, small micro-organization should not. So that's, if we're talking 1, 2, 3 people, okay, maybe it's an overkill. But if we are talking about a big organization, that's definitely AI register, that's definitely impact assessment, that's definitely incident log on a smaller scale, not on the country scale, due diligence of the vendors. So basically, are you releasing your data so it's trained on or not? And of course, reporting to the board, reporting to leadership. What we see in practice right now is not only regulators are asking for AI compliance, also the governments and also bigger suppliers. So for example, if you are working with bigger banks, they always will ask you, are you using AI for which purposes? So that's part of their due diligence. Definitely with governments, they're also asking, are you using AI, what's the purpose? And of course, insurance. With lawyers, yes, we have high insurance obligations, and insurance is definitely, insurance agencies are definitely looking into use of AI. So questions for leaders. So I have just summarized a couple for you here. What AI is being used inside the organizations already? Could we defend an AI system decision tomorrow? Are people using AI in the shadow because we gave them no safe pathway? That is probably one of the biggest messages from this talk. Which cases affect rights, safety, jobs, privacy, or service access? Who owns AI risk and where is it reported? Here are my details. Please feel free to reach out if you want deeper legal analysis or you want further references to legislation or cases that I have referred to in this presentation. Please feel free to reach out. And yeah, waiting for AI legislation is not the plan. This is, it's already in. Thank you.
So we do have time for a few questions, if people are happy to hang around. So I see there's a couple in the app already, which we'll look at. But if other people have questions and they want to put them into the website, do that now. And you can also upvote the questions that are there if sort of an idea is already captured. So maybe the first question is, given Australian law is already governing AI in the ways that you've talked about, and maybe also Devon talked about previously, if we did have an AI Act, like what would it bring to the table? Like what's the gap that could be filled, or is there no gap?
Okay, in my view, almost nothing. So at the moment, almost nothing. But maybe incident reporting, maybe that's one of the areas. But I don't know, Australian Signals Directorate is already doing some of this work. I think with the existing, like my personal opinion as a lawyer, I think we are regulated sufficiently with the existing legislation. So if there was an AI Act, what it would do, it would centralize, of course, because we have federal system. We have federal system with New South Wales, for example, and 9 jurisdictions, with 9 jurisdictions. So first question you have to ask, is it Commonwealth legislation? Is it state jurisdiction? The second question you have to ask, what kind of, so that's, I'm going back to my book, which is National Uniform Legislation. What kind of legislation is this? Will it apply uniformly across Australia, or will it be, how are we going to implement it? If it is, so for example, if it is Commonwealth legislation and it's in the referred, which is the most uniform structure, then maybe to bring harmonization, yes, maybe we will need it, but that's the only argument. I don't see any other arguments. Only the argument would be harmonization, unification, and clarity of regulation, and that's it. But absence of liability is not an argument, because there is existing common law, there is existing legislation. I don't see it from this perspective. Thank you. That's a good question.
Yeah, I mean, maybe just to dive into that a little bit more, I guess one of the questions that comes up is what happens when an AI agent exceeds its authority. So like we have existing law of agency. So if you have a real estate agent acting on your behalf and the real estate agent does something that you didn't authorize, that real estate agent's liable. But would that apply to an AI agent? Like I recall a personal experience where I'd told an AI agent to log on to government websites and pull down some information, put it in a file for me, and that AI agent would run into 403 areas where it wasn't allowed on government websites, and it would just say, oh, no worries, and then like bypass the government restrictions, gain access to the website, and then pull the file down anyway, which seems to be a cybercrime to me. But like, I thought there's a lack of clarity about, like, did Greg Sadler commit that cybercrime, or did Sam Altman commit that cybercrime, or did just no one commit it, and a cybercrime happened that like mens rea and actus reus didn't line up, and actually it's fine. So,
perfect. This is perfect question. Exactly. Agency law is existing law, and what's good about agency law, it's common law. Legislation can apply at Commonwealth and, for example, New South Wales level. But common law, there is a famous saying, there is but one common law in Australia. So common law is the same. Agency is the same agency. Therefore, agency law principles are the same across Australia, which is great. And if agent has, so that goes into that liability fault line. So we really need the decision of the court to guide us to who will be more responsible. How will the court assign this liability? But that's perfect. That's a really, really good question.
Yeah, okay. So maybe the next question I'll jump to is, how much liability can AI companies push off to others through contracts? So I think the question here is that, like, when you sign up to use Claude, it kind of says like, well, all outputs are your responsibility. And so like, you know, we saw Elon Musk's XAI manufacturing child abuse material, and obviously that contract said like, well, these outputs are your responsibility, not our responsibility. Like, does that work at a contract law to sort of say yes, all the users' problem, or does that?
Another perfect question. So this goes into two arguments. My personal opinion, and I think we will come to it as a country, 100% we will come to it as a country. There must be a liability fund. I think like in insurance, so we know AI will be harmful at the end. There must be a liability fund for AI companies that come to our market. So for example, mining company, they come to our market. We ask them to put millions of dollars in environmental fund. Apartment, if we are building apartment block, we have a sinking fund, because apartment eventually it will break, it will go down. So we have the sinking fund. Same with lawyers. I'm an amazing lawyer, but I make mistakes, and I have my insurance and professional liability insurance. And if I make a mistake, yes, my insurance applies. So we have to have something like environmental sinking fund, however you call it, liability fund for AI companies that come to the market. The second part of this, the answer to this question is, What's fantastic about Australia, we have Australian consumer law, and there is a prohibition against unfair contract terms. So with the liability, you can push it only so far. So with the big banks, for example, if they have unfair contract terms in their contracts, the part that is unfair can be excluded from the contract. So if, I don't know, Elon Musk's or whoever's AI or has been found to contain unfair contract terms, these terms can be removed and not applied to a particular situation. But yeah, that's a good question.
So maybe one more question. What do you see as the trend around algorithmic explainability? What are the likely ways forward?
For the opacity problem of the explainability of decision making,
yes.
or
yeah.
Yes.
Yeah.
So you mentioned around opacity being one of the core problems. Where do you see that trend going, and also any sort of cases that you think you're monitoring and worth monitoring in the short to medium term?
so okay. In my research, and so even without opacity problem, we have the problem. Even without opacity. So Robodebt, as you're familiar, there was nothing about opacity. It was simple algorithm, it's simple mathematical formula. So it wasn't even opacity. So even without opacity, we have this huge problem of the explainability of decision making. After opacity, after automatic decision making, yes, legally, I don't know where we are going. No, I can't see, and there will be new reforms in force from December 2026. But yes, that's a big problem. That's, opacity of decision making. It dropped off of dialogue, but I think you're right, it should come back to the dialogue.
So no countries or no jurisdictions are leading into this, in your view?
I haven't seen it in my research. I haven't seen somebody who has really solved this problem. I haven't seen. I have seen a lot of academics who are raising this issue, but I haven't seen countries who resolve that issue. Thank you.
Take a look at the Real Pages case in the US, which goes to this topic. So the ACC took the case quite a few years ago now, the Trivago case.
Ah,
There's
yes.
a current case, which is
Misleading.
the Real Pages case in the US, which is a modern version of the civil suit.
Yes, that included misleading and deceptive conduct. That's good. Yeah. But yes, no. But they argued, Trivago argued, they didn't know what the algorithm was doing, but of course they knew, and of course they made money out of it. Thank you.
Okay, well, thank you so much for your help today.